morning again. I would like to reserve 5 minutes of my time for rebuttal. My name is Eric Zagrins, representing the appellant Valley of the Eagles, LLC. May it please the court. The trial court committed 3 abuses of discretion in connection with this matter. This was an administrative appeal from the Lorain County Board of Revision. The standard that the trial court had to employ in taking an administrative appeal from the Board of Revision is independently to weigh and evaluate all of the evidence properly before it, giving no deference to the decision of the administrative board, the Board of Revision before it, and to make a thorough and comprehensive review of that evidence rather than merely a rubber stamping of it. The court must consider all of the evidence afresh and may in its discretion admit additional evidence into the record. The court has to do that kind of review, and as I said, the Supreme Court of Ohio has said in both the Black and the Park Ridge cases that it may accept additional evidence. The first abuse of discretion was to accept the argument, and I emphasize argument, with no evidentiary support in the administrative record or before the trial court, that the 17 parcels comprising the Valley of the Eagles property were supposedly one economic unit, and therefore even if the parcel in question that has the $1.35 million building assessed on it and assessing taxes on that building, on that structure, which does not in fact exist on that parcel, the argument of the appellees was to the trial court, well, this is one economic unit. It doesn't matter if there's a mistake that the building isn't on parcel A, if it's really on parcel B or parcel C, all 17 parcels comprise one economic unit.
Maybe I'm remembering wrong. I thought that perhaps part of the building was on the parcel at issue.
Your Honor, there is literally a corner comprising of a few square feet of the building that encroaches over across the property line. The vast majority of the empty and abandoned and in a state of decrepit disrepair back in 2014, but that structure, the 99% of that structure, is on a different parcel.
Is the valuation of that different parcel being appealed as well?
No, Your Honor, because the valuation of that different parcel did not include whatever the small value of that building would have been in 2014. It was only the value of the land, and there was nothing to appeal. But in front of the trial court,
it had a building on it.
Pardon?
But it had whatever condition the building was in. It wasn't just land. It did have 99% of the building sitting on it.
Yes, Your Honor, but there was nothing to appeal in the assessment for 2014 because the assessment for 2014 didn't reflect that parcel as having the building on it.
Right.
And there was no argument.
So it's an inaccurate assessment.
That's correct. It was an inaccurate assessment. The county didn't appeal the inaccurate assessment. It wasn't for the property owner to appeal an inaccurate assessment that goes in the property owner's favor when it doesn't properly reflect the building. Now, if the county had said, well, wait, we made a mistake, the building isn't on parcel A, we acknowledge it's on parcel B, then that would have been a different kind of an appeal that would have been taken at that point with different evidence submitted to the Board of Revision to show, okay, now we've got the building reflected on the correct parcel, but the value of the building is not $1.35 million because it's been abandoned for a number of years. It's in a total state of disrepair. It cannot support or obtain an occupancy permit. No one can be in it. No one can use it.
Was any of that evidence before the court?
Absolutely not, Your Honor, because it was not an issue that was raised before the Board of Revision. So for the first time, there is this economic entity argument or economic enterprise argument presented to the trial court. And I'm fine with that, or I would have been fine with that argument being raised if there were evidence being introduced to support it, because then we would have had the opportunity before the trial court to introduce counter evidence that says it's not one economic enterprise, there are at least three separate uses to which the entire 17 acres is being put. There's a residential development going on the west end of the property. There is a golf course on the north end of the property.
Is the property at issue in that portion that's going to be developed as a golf course?
There's a golf course, Your Honor, there is a residential section, and then there is this clubhouse building that is on.
The parcel of land that's at issue here.
Yes, Your
Is
Honor.
that included in what is going to be the golf course?
No, Your Honor, it is not.
Is it included in the parcel where they have residences?
No, Your Honor, it is not.
So where is it?
It is in the middle between those two
But
sections.
it's not intended to become part of the golf course.
It will be used by people who go there to golf, I'm sure, absolutely. It will be used.
part of the golf course.
Well, no, Your Honor, because it will be used for parties and people going there to have dinner, and be used by the residents who will come and use it for various functions. That doesn't mean it's part of the residential development, and just because it's being used by golfers who to have lunch while they're playing golf doesn't mean it's part of the golf
Well,
course.
they're having lunch in the building, of which a tiny bit of it is sitting on that parcel.
That's true. But my point is that it's not one economic unit, and the trial court should have accepted additional evidence, allowing us to have the opportunity to present our appraiser and our economist to explain that this is not something that should be treated as one economic unit. So that's the first abuse that we maintain. There was no evidence to support the mere argument that this is one economic unit. There has to be evidence.
But, okay, I get what you're saying, but hypothetically, that building itself is one economic unit. It's worth
Yes, Your Honor.
$4 million, and it's a building.
Yes, Your Honor, absolutely.
It's sitting on two separate parcels.
Yes.
Okay, I guess that's.
No, I get that. That's absolutely right. But the building in its state of disrepair without being eligible for an occupancy permit is not worth $1.35 million. No arm's length buyer in their right mind would pay $1.35 million or anything close to that for that building in 2014. That's the point. There should have been evidence before that the trial court would have taken if that argument that was not made in the Board of Revision, and there was no evidence of any kind submitted in the Board of Revision by the appellees on that point. If that was what they were going to do, then there should have been additional evidence taken by the trial court on that point, not just an assumption being made. The second abuse, and the trial court merely assumed that there was no argument being made on the valuation of the building. That assumption is absolutely fallacious. Of course there was an argument about the valuation of the building. The building was in a state of almost falling down. The structure, the frame of the building in 2014 was in place, but it was in such a state of disrepair that the city would not give an occupancy permit. It needed massive renovation, and it couldn't possibly be worth $1.35 million, and our appraiser would have said so had that issue been presented to the Board of Revision, and again, if it had been the trial court's wish to hear additional evidence on it. That's where we have an issue with this very sparse record with no contrary evidence to the evidence that the appraiser submitted, and the appellees persist in calling our appraiser a real estate salesman. Well, the fact that he is a real estate salesman in some part of his career doesn't mean that he is also not qualified to act as an appraiser, and has in fact been hired to act as an expert appraiser in other matters, including this one. So the only evidence that was in front of the Board of Revision, and the only evidence that the trial court considered, since the trial court did not, in its discretion, accept additional evidence, even though we tried and asked the trial court to do so, was the expert appraisal report of our expert, who said that the value of this parcel was not the $1.48 million that the county assessed to it, because it didn't have a $1.35 million structure on it. The value of the land, he said, was worth the difference of $130,000 approximately. But it wasn't worth the additional $1.35 million that the county tried to assess to it. So that is the...
Counsel, you've entered your rebuttal time.
Thank you, Your Honor. I appreciate that.
Good morning, I'm John Kilroy for the Lorain County Auditor of the Lorain County Board of Revision. I'd like to take 7 minutes and give the 8 minutes to the Board of Education.
Okay.
First of all, the Valley of the Eagles contends that both the 2014 and 2015 values are at issue. The only issue is that was before the Board of Revision of the Common Police Court was the tax year 2014 valuation. Valley of the Eagles argues that the evidence supports its claim for reduction in value, but does not cite any evidence in the record. Not a single citation of the transcript is in the appellate's brief. Statements of counsel, like we just heard, take the place of evidence and testimony of witnesses. Valley of the Eagles argues that its appraiser presented a comprehensive appraisal, but curiously doesn't cite or quote the appraisal report anywhere in its brief. Where Valley of the Eagles does cite the record, it misleads. On the bottom of page 3 in the appellant's brief, it starts with, it's undisputed that this parcel is one of 17 parcels that comprise approximately 200 acres and were formerly known as Spring Valley Country Club. This particular parcel is landlocked, is in a floodplain, and is unbuildable. That's the court's entry. What it leaves out is, right after the words country club, it says appellant VOE contends that the particular parcel is landlocked. So by omitting appellant VOE contends that, the one citation of the record is misleading. The Valley of the Eagles in its brief incorrectly stated the standard of review, which is an abuse of discretion, and I'm glad that it seemed like a better description on oral argument. The Valley of the Eagles does not have a right to a hearing de novo with the common pleas, but rather a review de novo. This is statutory under Revised Code 5717.05, which states the court may hear the appeal on the record and the evidence thus submitted, or it may hear and consider additional evidence. There was no good cause shown to introduce additional evidence. There was no motion to enlarge the record or any suggestion that additional evidence might be forthcoming. The complainant had a affirmative duty to present all its evidence at the Board of Revision, and we presume that it did present what it wanted to. Revised Code 5715.19G says a complainant shall provide to the Board of Revision all information or evidence within the complainant's knowledge or possession. A complainant who fails to provide such information is precluded from introducing it on appeal to the Board of Tax Appeals or the Common Pleas. Except the Board of Tax Appeals or court may admit it and consider evidence if the complainant shows good cause. Again, there was no good cause for additional evidence. The Common Pleas Court did not abuse its discretion in affirming the Board of Revision decision. The court had ample reason to conclude that the evidence was insufficient to support a change in value. The only evidence offered was by Kevin B. Riley, who is not a licensed appraiser in the state of Ohio. He is a licensed real estate salesperson, which does not preclude him, it doesn't make it illegal for him to do an appraisal if it's not for mortgage purposes. But he's got to show that he's qualified to express this opinion. There's no statement of qualifications on the record. There's no statement of qualifications in his appraisal report. So we don't know why he claims to have expertise or to be qualified to state an opinion. The appraisal report compares to golf course sales. We're hearing that this is not golf course property, yet this appraiser who opposing counsel calls an expert, used only golf course sales to come up with the land value. The report has the land value of the land only. It contains photos of a building that were taken 18 months later that show the condition at that point, but don't show the condition 18 months previous. In fact, we don't have anything on the condition 18 months previous. We only have statements of counsel. Valley of the Eagles presented no information on the precise location of the building. The appellant's brief argues that the building's not there at all. More correctly stated, part of the building is on the subject parcel, part of it's on the other. The owner placed the value on the one parcel. There could be an argument it should have been on the other parcel, but the value is there. And the taxes on that building would be the same. It's the same ownership. Taxes would be the same no matter which parcel it was on. Kevin B. Riley is not a surveyor. There was no GIS or survey information introduced. The burden is on somebody showing it's on the wrong parcel to show how much of the building, if any, is on the wrong parcel. There's no evidence in the appraisal on the value of the building. Even if statements of counsel on the condition of the building were taken as evidence, the poor condition of the building does not prove or disprove a particular value. The common pleas entry, appended to both the Valley of the Eagles brief and my own, shows that the court took care in looking at the record and making the decision. So the Valley of the Eagles did not provide sufficient evidence at the Board of Revision, did not show good cause to have an evidentiary hearing, the Court of Common Pleas, did not cite or quote the appraisal report, did not cite or quote the transcript, and did not show anywhere where there was abuse of discretion.
Thank you.
May it please the court, my name is Barrett Hubbard. I represent the Elyria City School District Board of Education in this matter. The important thing to note from the get-go is that the burden from the very beginning of a party challenging the auditor's value at the Board of Revision is on the challenger, in this case the taxpayer, and remains on the challenger until they are able to provide competent probative evidence of what the value of the property should be and that the auditor's value is incorrect. We would note in this case that the trial court here ruled that they were not that they had not provided sufficient evidence, specifically that they did not challenge the numerical figures for land value or building value. And of important notes here is that they are not entitled to judgment in their favor simply because they are the only party to submit evidence. That was discussed in Glicks by the 10th District Court of Appeals, in which they determined that simply being the only party to present evidence without rebuttal, if it's not competent probative evidence, it is not sufficient and they are not entitled to judgment. So looking at the evidence that was before the Board of Revision and therefore before the trial court, as to land value, the Valley of the Eagles did present the appraisal report of Kevin Riley, and whether it is sufficient evidence, ignoring what potential defaults there might be in his qualifications, he did opine a value as to the land, and that value supported the value that was in place by the county. And he specifically did not attempt to value the improvements on the property. He only rendered an opinion as to the value of land. As to the building value, we don't have an appraisal that shows what the value was worth. And we also simply have a few passing comments by the property owner or the representative of the property owner, Mr. Corno, in which case he states certain elements regarding the condition of the property, but as has been decided by the Supreme Court previously, evidence of repairs or the cost of needed repairs, although it may be a factor in arriving at the true value, that alone is not sufficient to prove the value of the property. We have no valuation evidence submitted before the Board of Revision or submitted before the trial court showing what the value of the building was. And in fact, it wasn't really even made an issue at the Board of Revision, and the burden would have been upon the taxpayer to show what that value was worth. As has been noted, the court is not required to hold a new hearing. the trial court is not required to hold a new hearing. The language in the statute is permissive, and the court cited, the Black court that was cited clearly indicates that the decision whether or not to hold a new hearing, a new evidentiary hearing, is at the discretion of the trial court, and here they did not abuse their discretion by not allowing additional evidence. The appellant has also claimed that in some way the court had a duty to independently appraise this property, and that was discussed previously in Colonial Village that we cited, where it is noted that the court's requirement to independently value the property only gets triggered once evidence has been submitted to show that the county's appraisal value is wrong. And really the only evidence that was presented before the trial court here is the evidence or the testimony of Mr. Riley, which indicated that at least as to the land value, the valuation was correct, and he made no statements as to the value of the building. Also of issue here is whether or not this was a single economic unit. And although appellant is characterizing that the evidence shows that there was nothing presented regarding whether or not this was a single economic unit, that is not correct, and that belies the record in this case. It is true that the only witnesses here were the property owner's representative and the appraiser, but a number of things came out during the testimony of those two individuals. Specifically, that this property, the entire 190 acres, or 196 plus or minus acres, has historically been used as a golf course. It is being redeveloped as a golf course. It has been and continues to be under common ownership and used together with the neighboring land. When questioned, the owner testified that he would not be willing to sell off this 19-acre parcel independent of everything else because he intends on using it as part of his redevelopment project. Also noted, this 19 acres itself is unbuildable, is landlocked, and is in a floodplain. With those things in mind, it is unreasonable to envision a scenario that would market these 19 acres separate of the adjacent land, which is necessary to access the property, which has been used in conjunction with the property, and which, by the statements of the witnesses at the Board of Revision, will continue to be used together for various purposes on this single 196-acre plot of land. Additionally, although the appraiser at the Board of Revision did not opine a value as to the building, he did make some interesting comments. He said he had looked at the aerial maps. It was his opinion, and whether that opinion is right or not, it was his opinion and his testimony that a portion of the building did in fact lie on this parcel of land. And although he characterized the portion of the building as insignificant, one has to ask, what is a significant portion of a neighbor's building that exists on your land? It would seem that an insignificant portion of the building would be no portion of the building. But in this case, we see that the building, according to the testimony that was present in the record and presented before the Board of Revision and available to the trial court, that the building did span both parcels. As such, it is perfectly reasonable that the trial court found that there was sufficient evidence to see that this was a single economic unit. And being a single economic unit, it is wholly appropriate for the auditor to value that economic unit as one and assign the value of the building to whichever parcels it determines. It need not be assigned to a single parcel or a particular parcel. It need not be split among all the parcels, as long as the entire economic unit is valued appropriately, as long as that economic unit is commonly owned, commonly used. It is wholly appropriate to do what the auditor did. And absent no challenge as to what the value of the building is, and absent in presence of a confirmation of the value of the land, we feel that the court came to the right conclusion in upholding or in determining that the auditor's value was correct, or finding that the appellant here failed in meeting their burden to show that the value was incorrect. And we're asking that the court here affirm the trial court's decision. Thank you.
Thank you, Your Honor. First of all, we agree that the only valuation in question is for the 2014 year. We agree with that point. Look, this economic enterprise as a whole argument should not be used by a taxing authority as a sandbag for a taxpayer. The argument was never, those words were never presented in front of the Board of Revision. The first time we hear it is in front of the trial court. And a taxpayer should not be required to raise and address all possible arguments that the county might come up, maybe some impossible or implausible arguments that the county might assert in support of the presentation about the value. Of course, the value of the parcel was in question, and as appellees conceded in their argument just now, the board heard two witnesses in the administrative hearing, not only from the appraiser, but also from the representative of the property owner. And that uncontradicted testimony from the representative of the property owner was that the building was in big need of repair. The building was in a state of disrepair and couldn't therefore be worth $1.35 million. So for the trial court merely to assume without, I agree with what Mr. Kilroy said about that the trial court did not cite or quote the transcript at all in the trial court's opinion. For the trial court merely to assume, without any evidentiary support from the administrative record, that there was no challenge to the value of the building is a mistake, an abuse of the court's discretion. Where you have this kind of factual discrepancy being presented to a trial court, this kind of contention over where the building is placed, what the value of the building actually is in a state of disrepair or not, and whether or not 200 acres of land in 17 parcels should be treated as one or not treated as one, where the golf course comprises only 20% of those 200 acres. Only 1/5 of that entire area is golf course. Where you have this kind of factual discrepancy, then I submit respectfully to the court that it's an abuse of discretion not to accept additional evidence to clear up the factual issues that the administrative record have left unresolved. Judge Schaefer, I thought you wanted to say
Well,
something.
I'm having trouble understanding why, if there was a dispute over the valuation of the building, and you're alleging that it was in disrepair, and we had somebody there to do, was there a, word is escaping me, somebody would go in and inspect the property and present, here, it's really not worth 1.3 million, it's only worth 1.1 because it needs new plumbing, all plumbing's been pulled out. I mean, all that stuff was presented to the trial court, and they could see that it's not worth 1.4, it's really only worth 900 because it has no plumbing. The ceilings caved in, the floors are falling through, I mean, the boilers are out. Was there any of that stuff presented to the trial court to show that this building is not worth this much money?
Absolutely not, Your Honor, because the trial court didn't accept, I beg to differ with my friend on the other side. I did ask the trial court to accept evidence. The trial court did not accept any new evidence.
Okay, and it's your contention that this building is not on this parcel anyway?
Well, that's correct.
And,
That was
and you never argued that the building is in fact on this other parcel, and in fact, it's not even worth what, even if you were to translate that 1.4 million onto this parcel, it wouldn't even be worth that if you put it over here. That was never argued either, right?
I didn't have the chance to argue that in the trial court. That's right.
But you
Your Honor.
didn't appeal the value of that other parcel.
No, Your Honor, the property owner did not appeal the value of the other parcel because the value of the other parcel, not having a building on it,
But it does in fact have a building.
that's not what the county reflected. So
I'm
again,
saying, but if your aerial GIS view would show that building 99% of it being sitting on that parcel.
yes,
Okay.
that's true, it would. But why is the taxpayer going to be put to the burden of appealing a valuation on another parcel that the county doesn't include the building on? There's nothing to appeal.
Well, I guess because in my mind, if all you're doing is saying, well, it's not on this parcel, but technically then it's not on any parcel, at all, because it's not on that other one either, then that's a windfall for the landowner, because he's get this billion, but he's not gonna pay any taxes on at all. So I'm having a hard time wrapping my mind around the fact that the other parcel wasn't appealed, because it's got a wrong valuation on it too.
And I understand your Honor's point, and it's an appealing point, and it's a fairness point. I get it. But is that something that the law clearly states so that a taxpayer can understand it? When a taxpayer is going in to make this kind of an appeal before a board of revision, hey, you have an affirmative duty, taxpayer, to appeal a value that you do not think is too high as stated, but because the county made a mistake and didn't make it as high as it should have been, you have the burden of going in and appealing it and increasing the value of that land.
Well,
I'm not
wouldn't it
sure,
be easier?
I'm not sure that
It
that,
would be easier in this case, wouldn't it?
yes, Your Honor, but I'm not sure that that's a burden that the law clearly states before this case should be placed on a taxpayer. And if we're talking about fairness
Thank you,
in,
counsel. Thank you. Are you satisfied with that? Because we're out of time, we've been out of time. I just
Thank you,
allow
Your
you to answer the question.
thank you, Your Honor.
Thank you. The court will take the matter under advisement and issue a written opinion that will be sent to both sides.